You're listening to Audiology. Support our work on Patreon and be sure to submit your requests for topics in the comments below. In 1984, the U.S. Supreme Court made a significant decision in a case titled Chevron U.S.A. Incorporated versus Natural Resources Defense Council Incorporated, and it fundamentally changed how courts view decisions made by government agencies. This case introduced us to something known as Chevron deference. This meant that when a government agency decided on how to interpret a law, the courts would generally defer to it, but this would only happen if two criteria were met. First, the law had to be ambiguous about the issue the agency was addressing, and second, the agency's interpretation had to be considered reasonable. The case originated from a disagreement about the Clean Air Act of 1963, specifically concerning what qualified as a source of air pollution. The Environmental Protection Act, or EPA, had originally defined a source as essentially any significant modification to a plant or factory. However, in 1981, the EPA altered its position, stating a source referred to the entire plant or factory itself. This new interpretation allowed for easier implementation of new projects within companies as long as the overall amount of pollution they produced did not increase. The Natural Resources Defense Council, an environmental advocacy group, challenged the legality of this change. Fast forward 40 years, and in June 2024, the Supreme Court ruled in a case known as Loper Bright Enterprises versus Raimondo, with a decision of 6-3, that Chevron deference was actually in conflict with the Administrative Procedure Act, effectively nullifying the Chevron decision. The influence of Chevron was substantial. It served as a foundation of U.S. administrative law and was referenced in thousands of legal cases over 4 decades. However, its overturning signifies a substantial change in the way courts will approach agency interpretations of laws in the future. The Supreme Court decided in Marbury v. Madison that U.S. federal courts have the power to review laws passed by Congress and can invalidate any law that contravenes the Constitution. However, the Constitution doesn't specifically restrict how much power federal agencies can receive from Congress. These limits are generally outlined in the laws that Congress passes. Additionally, it's important to note that federal courts are designed to have a limited jurisdiction. This means they did not have the authority to deal with administrative issues until Congress gave them that power in 1948. In 1974, the Supreme Court clarified that when it comes to relying on how a government agency interprets a law, consistency is key. The court mentioned that the value given to an agency's interpretation relies on a few things. One major factor is whether the interpretation is consistent with the agency's previous and subsequent statement. Another factor is whether the interpretation aligns with the intent of Congress when they pass the law. To sum it up, for an agency's interpretation of a law to be respected and followed, it must not only align with the agency's own past and future interpretations, but must also clearly reflect the original goals Congress had in mind. In 1977, the U.S. made a significant change to the Clean Air Act, initially passed in 1963. This update required any large project that could significantly pollute the air to obtain a special kind of permission, known as New Source Review, from the Environmental Protection Agency, or EPA. Initially, the EPA considered any major piece, like a smokestack or boiler at a facility, as a potential source of pollution under this law. Fast forward to 1981, when Ronald Reagan assumed the role of president, the EPA shifted its stance. It began to view the term source as referring to an entire plant or factory rather than just a part of it. This interpretation meant that changes within a facility would only require this new source review if they would increase the plant's total pollution output. Essentially, companies could now build new projects that might pollute, but they could avoid the review process by also making some improvements to reduce pollution elsewhere in the facility. This new interpretation by the EPA opened the door for companies to proceed with their industrial activities more effortlessly, as long as the overall pollution levels didn't increase. However, not everyone was content with this change. The Natural Resources Defense Council, an environmentalist group, challenged the EPA's new rule in court in late 1981. They took their case to the U.S. Court of Appeals for the District of Columbia Circuit. The following year, the court, with a decision penned by Judge Ruth Bader Ginsburg, who would later join the Supreme Court, sided with the Natural Resources Defense Council. It declared that the EPA's new way of interpreting source didn't align with how it had been previously understood and ruled it invalid. Chevron Corporation, which had been impacted by the EPA's new rule, didn't accept this decision, lying down, and took the matter to the Supreme Court. On June 25, 1984, the Supreme Court made a unanimous decision with a vote of 6-0 supporting the Environmental Protection Agency, which overturned a previous decision by the District of Columbia Circuit Court. This case centered around the interpretation of the word source within the Clean Air Act. Justice John Paul Stevens, who wrote the opinion for the court, stated that the ambiguous meaning of source suggested that Congress intended to leave it up to the Environmental Protection Agency to determine its definition as part of a policy decision. The court criticized the District of Columbia Circuit for overstepping its bounds by attempting to influence government policy on regulating emissions from air pollution. They highlighted a fundamental principle. The judiciary, which doesn't represent any political constituency since its members are not elected, should not get involved in political decisions. This is a task meant for political branches of government, as outlined in the Constitution. The court went on to say that when there's a dispute over the interpretation of a law that essentially boils down to whether an agency's policy is wise, the challenge will not stand if the agency's choice is reasonable within the framework Congress provided. This is based on the understanding that judges do not have constituents, and thus should defer to legitimate policy decisions made by entities that do. The Supreme Court stressed that deciding on policy matters and navigating through competing public interests are responsibilities that fall within the realm of the political branches, not the judiciary. If a law Congress passes is somewhat ambiguous, this might actually be a way for Congress to give the executive agency responsible for implementing the law the discretion to interpret it. The court explained that agencies are expected to develop policies and rules to bridge any gaps Congress might have left, either intentionally or by omission. Regulations set by these agencies hold significant weight, except in situations where they're deemed arbitrary, nonsensical, or clearly against the statute itself. Oftentimes, Congress delegates authority to agencies implicitly, not outright, and it's not up to the courts to overrule an agency's interpretation if it's considered reasonable. The Supreme Court outlined a two-step process for federal courts to follow when dealing with challenges to how an agency interprets a law, a process now referred to as the Chevron Doctrine. First, the question must be asked, has Congress directly addressed the issue? If Congress's intention is clear, then that concludes the matter. However, if there's ambiguity or silence on the issue, the court must then decide if the agency's interpretation is a reasonable one. Under this doctrine, a court must first determine if the law clearly addresses the question at hand. If not, the next step is to assess whether the agency's proposed interpretation is rational or permissible. Only if the court finds the interpretation unreasonable can it then offer its own interpretation of the law. The Chevron case is a significant matter in American legal circles, often being the most discussed case in the field of administrative law. However, some experts believe the impact of this decision on the Supreme Court's way of thinking was not all that revolutionary and mainly just formalized what the court was already undertaking. Essentially, the Chevron case established a standard known as the Chevron deference, where courts should rely on federal agencies' interpretations of ambiguous laws passed by Congress that those agencies manage. This principle has underpinned many rulings, including environmental regulations by the Environmental Protection Agency and the Federal Communications Commission's views on net neutrality. In 2002, Chevron invoked this very precedent to win in another Supreme Court case, Chevron U.S.A. Incorporated versus Chazabal. The unanimous decision here supported an Equal Employment Opportunity Commission rule. It stated an employer could reject a job applicant if the applicant's health condition could significantly harm their health on the job. The Supreme Court in the 21st century began to tighten the control a bit on when the Chevron deference applies, concentrating on agency decisions with the force of law. Informally known as Chevron Step 0, this new approach suggests that while formal, legally binding regulations might receive the Chevron endorsement, less formal communications, like advisory letters from agencies, probably will not. Nonetheless, these might receive some degree of deference based on an older standard from a 1944 case, Skidmore versus Swift and Company. In fact, in specific cases like King versus Burwell in 2015, the Supreme Court hinted that Chevron deference might not be suitable for actions with significant economic or political stakes, suggesting a more narrow application of the doctrine might be in order. A notable Supreme Court case, West Virginia versus Environmental Protection Agency in 2022, introduced the Major Questions Doctrine, further dialing back the Chevron deference. This newer principle takes a skeptical view at agency decisions that aren't explicitly supported by Congress and carry significant economic or political consequences, possibly deeming them overstepping. For example, this doctrine was applied to question the Environmental Protection Agency's authority on imposing broad emission reduction measures that reach beyond power plants themselves due to the steep costs involved. Similarly, in Biden versus Nebraska in 2023, the court ruled that the Department of Education overreached by attempting to cancel a massive amount of federal student loans without clear congressional support. Looking ahead, the Supreme Court decided to revisit the Chevron deference in Loper Bright Enterprises versus Raimondo in January 2024. The case was about fishermen being required to pay for observers on their boats, a rule upheld by lower courts because of the Chevron deference, but contested as a reason to challenge the rule's validity. Ultimately, in June 2024, the Supreme Court voted 6-3 to overturn the Chevron doctrine in the Loper Bright decision. The removal of the Chevron precedent raises questions about future regulations, especially in health and environmental fields. Lawyers suggest that this could lead to a lot of uncertainty and instability, opening the floodgates for legal challenges against decisions made by key agencies like the Food and Drug Administration, Environmental Protection Agency, and Centers for Medicare and Medicaid Services. On January 11, 2017, the U.S. House of Representatives, during its 115th Congress, approved a significant piece of legislation known as the Regulatory Accountability Act of 2017. This bill, if it becomes law, aims to modify the established principle known as Chevron deference. Interestingly, Supreme Court Justice Neil Gorsuch, whose mother, Ann Gorsuch, was the head of the Environmental Protection Agency during the events leading to the Chevron decision, has previously expressed objections to Chevron deference. Many analysts predict that Justice Gorsuch may oppose Chevron deference in his decisions on the Supreme Court. In a notable Supreme Court case, City of Arlington, Texas versus FCC, Chief Justice Roberts, along with Justices Kennedy and Alito, voiced strong reservations about granting excessive Chevron deference to federal agencies. Chief Justice Roberts stated, "A court should not defer to an agency until the court decides on its own that the agency is entitled to deference." This sentiment echoes a fundamental issue with excessive deference. It may infringe upon the judiciary's primary role of interpreting the law. The principle known as Chevron deference originated from the Supreme Court's decision in Chevron U.S.A. Incorporation versus Natural Resources Defense Council Incorporation. This doctrine outlines a two-step process for courts to analyze an agency's interpretation of a statute it administers. Essentially, if the law is clear, the agency must follow the law. If it's ambiguous, courts generally defer to the agency's interpretation as long as it is reasonable. The landmark case Marbury v. Madison established the judiciary's duty to declare what the law is, a role that has not diminished with the rise of the modern administrative state. This duty encompasses the review of agency actions, as detailed in the Administrative Procedure Act, which requires courts to resolve all relevant questions of law and to overturn agency actions that contradict legal interpretation. Before Justice Gorsuch joined the Supreme Court as a judge on the 10th Circuit, he criticized the notion that agencies could essentially override court decisions, a stance he viewed as potentially unconstitutional. This critique underscores a significant tension between judicial authority and administrative actions under Chevron deference, the potential for agencies, driven by policy objectives, to infringe upon individual liberties in a manner inconsistent with judicial declarations of law. In the case of Waterkeeper Alliance versus EPA, the court indeed chose not to defer to the agency's interpretation, highlighting ongoing debates over the appropriate balance between judicial oversight and agency expertise in interpreting laws. In Arizona, the rules have changed regarding how courts handle cases involving state agencies. Back in April 2018, Governor Doug Ducey signed a law, House Bill 2238. This new regulation states that in legal disputes involving regulated parties, the courts must determine legal issues, including how to interpret laws or rules made by agencies independently. They are not supposed to rely on the agency's own interpretation anymore. However, there are a couple of exceptions to this rule, including matters related to healthcare appeals and agencies established by the State Corporation Commission. Down in Florida, voters made a significant choice in November 2018. They passed an amendment to the state's constitution that eliminated the court's ability to rely on administrative agencies' interpretations of laws or rules. Instead, courts and officers in administrative actions are required to interpret these laws and rules from the beginning, a process known as de novo interpretation. This amendment effectively put an end to a practice known as our deference in Florida, meaning agencies can't interpret their own rules in these situations. In Mississippi, a turning point occurred with a 2018 court case, King versus Mississippi Military Department. The state's Supreme Court made a decision that eliminated Chevron deference, a doctrine that previously allowed state-level agencies some latitude in how they interpreted laws affecting them. North Carolina's approach is a bit different. While the state's Supreme Court has rejected Chevron deference, it does allow a kind of limited deference to state agencies, similar to what is known as Skidmore deference. However, this hasn't prevented some lower courts in the state from adhering to the previous way of doing things under Chevron deference. Ohio joined the group of states changing how they deal with agency interpretations of laws in 2023. The Ohio Supreme Court decisively ended Chevron deference at the state level through a case called Twism Enterprises versus State Board of Registration. Finally, in Wisconsin, the state Supreme Court ruled against Chevron deference back in 2016 in a case known as Tetra Tech Incorporated versus Wisconsin Department of Revenue. Then, in 2018, Governor Scott Walker signed a bill into law that ensured courts would no longer defer to agencies' interpretations of laws, solidifying this stance across the state. Thanks for watching. Share your thoughts in the comments and subscribe for more content.